What's up? Sorry, I'm running a little late here. I'm supposed to start at 9. It's about 9:13, 9:15. Anyway, so I'll let this go for a second. What's up there, News Nebraska? I'll wait till we get a few people in here. Let me know if you got a wrench and you're in here. Welcome to the first episode of Friday Night Cites. We're going to go from 9 to 10. At least an hour. Try to keep it short. What's up, League Sides? What's up, Nat? Here to learn. I'm not a teacher. Disclosure, this is not legal advice. I just like sharing reading material. I cannot advise you. I'm not an attorney. I do not have a law degree. But should you get bored and you want to look up something that you see me read in this video, that's your own choosing. But I can't advise you to do so. I can share my experiences, and if you want to look some stuff up after I share my experiences, that's your choosing. So, that being said, it is sharing is caring. I got a mod in here yet? Anyone with a wrench? What's up, Bob Homestead? What's up there, real Jimmy? How we doing? How's the picture? How's sound? Man, how's my feed? We steady? Sub Civilian X. All right, so you guys got to forgive me as far as a little scattered tonight. This is the first one. Just trying to, be prepared. That's why I'm running a little late. I'm gonna finish this cigarette and my coffee. But basically tonight we're going to get into some stuff. I hear a lot of people mention 1983, 241 and 242. Occasionally a few others, not that often. We're going to talk about a few more unknown or less spoken of statutes. We're going to talk about some federal statutes. We're going to talk about some stuff for individuals that are, interested in what Indiana's books say. We're gonna get into the update on this court-appointed forensic advocate that I've been looking into, and we're also going to do a special something every Friday called a "Fuck the Police" quote of the week. And this is where police officers tend to say stupid shit a lot of the times, but sometimes they say something really stupid and they say it on camera. So we're going to do a fuck the police quote of the week, basically, where we quote something stupid a police officer said on video from that week. First episode, I'm going to quote one of my own videos, but after this, I'm going to try to quote a different video, somebody else's video, whatever, wherever the stupid quote comes from. What else? I don't know. We'll see. We'll do this first show here, and then this first episode, then we'll see. Based on feedback, you guys are the ones watching. We'll get some ideas from you guys. Yeah. All right. First off, actually, what do you guys want to talk about first? You guys want to do the we'll do the autism advocate shit here in a minute. All right. All right. So, United States Code, Title 18, Part 1, Chapter 13, Section 241 and 242, Conspiracy against rights, and deprivation of rights under color of law. A lot of people are very familiar with these, as well as 1983, 1985, 1988. There's a whole bunch of them. I believe 1988 covers attorney's fees. Don't quote me, though. Anyway, so if you're not familiar with Section 241 and Section 242, I'm going to go ahead and read this anyway. Section 241 of Title 18, Part 1, Chapter 13, Conspiracy against rights. If two or more persons conspire to injure, oppress, threaten, or intimidate any inhabitant of any state, territory, or district in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or laws of the United States, or because of his having so exercised the same, or if two or more persons go in disguise on the highway or on the premises of another with intent to prevent or hinder his free exercise or enjoyment of any right or privilege so secured, they shall be fined not more than $10,000 or imprisoned not more than 10 years or both. And if death results, they shall be subject to imprisonment for any term of years or for life. Section 242, deprivation of rights under color of law. Whoever under color of any law, statute, ordinance, regulation, or custom willfully subjects any inhabitant of any state, territory, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, or to different punishments, pains, or penalties on account of such inhabitant being an alien or by reason of his color or race than are prescribed for the punishment of citizens, shall be fined not more than $1,000 or imprisoned not more than 1 year or both. And if bodily injury results, shall be fined under this title or imprisoned not more than 10 years or both. And if death results, shall be subject to imprisonment for any term of years or for life. Okay. A lot of people are familiar with that. It's quoted quite a bit. All right. So, actually, before I get into this next one, I'm going to explain why. In the auditing community, you videotape. Real Jingy, yes we are. Matt, hey, I'll make you a mod tonight after this live feed. You hanging out? It's the or laws part that makes a huge difference in 18 U.S.C. 241 and 242. Correct. That's a whole nother conversation. So What we're going to get into is interference with commerce by threats or violence. 18 USC 1951. That's 18, or that's U.S. Code Title 18, Part 1, Chapter 95, 1951. We're going to get into RICO tonight, Mr. Duggins. Don't you worry. Now, interference with commerce is basically, we're going to get into it here in a minute. I'm going to explain why. You're out recording, okay, and basically you're exercising your First Amendment right. This could lead to further exercise of your First Amendment right in the form of petitioning your government for redress. If you're recording and this goes badly, you know, if you're auditing and they fail significantly, your responsibility as an auditor is to essentially notify their department and to insist that they are reprimanded for this. Now, should you attempt to file a complaint or something of that nature, there's further stuff that we're going to get into that, or get into with that. But basically, your phone is connected to the internet. When you're live streaming, this is interstate commerce. This is federal. You're on the internet live streaming, and essentially your phone, which we're going to get into, your electronic device, as a computer, essentially. Here in Indiana, we're going to get into that. But federally, it's covered under some different stuff. The definitions are usually the same. But when you're live streaming over the internet, you're basically interacting with federal commerce. Okay. Now, where is that real quick? Let me. All right, so the police stop you. They want your ID. We're not going to get into the ID thing. All right. But oftentimes the police threaten to take your phone. A case you're going to want to look into, I'll say it over and over again, is David Leon Riley v. California. It's 573 U.S. 2014. This is basically the case for if the police take your phone without a warrant, with the whole evidence of a crime thing. Riley v. California, United States Supreme Court case. All right, now, here in Indiana, we have Indiana Code 354318, offense against computer users. A person who knowingly or intentionally and who without authorization disrupts, denies, or causes the disruption or denial of a computer system services to an authorized user of the computer system services that are operated for, on behalf of, or in conjunction with another person in whole or part, or destroys or damages a computer system, or computer network, commits an offense against computer users, a level 6 felony. Now, basically, you know, one of these cops comes up, they take your phone, they smack your phone to try to break it, to block it, what the fuck ever. Here in Indiana, this is a felony. Okay, it's a level 6 felony. However, the offense is a level 5 felony if the offense was committed for the purpose of devising or executing any scheme or artifice to defraud or obtain property, or the offense interrupts or impairs a governmental operation. Okay. Now, essentially, when these police leave their duties and they do something that they don't need to be doing, they're not actually investigating a crime and protecting the public. They are impairing a governmental operation by a dereliction of duty. Okay. The offense is a level 4 felony if the offense endangers human life. In addition to any criminal penalties imposed for a violation of this section, a person who commits an offense described in subsection B commits a deceptive act that is actionable by the Attorney General under IC 24-5-0.5 and is subject to the remedies and penalties under IC 24-5-0.5. Okay. In Indiana, cop comes up, tries to take your phone, tries to smack your phone out of your hand and breaks it. It's a felony, and you can collect. So, since we're on it with the Indiana Code 3424-1, civil forfeiture requires the prosecuting attorney to file an affidavit of probable cause, which looks a little bit like that. This is Indianapolis's version. LaPorte County's is a little different. To file an affidavit of probable cause with the court not later than 7 days after property is seized, and provides for the return of the property to the owner if the court does not find probable cause. Establishes a procedure for an owner of real property or of a vehicle if the owner was not operating the vehicle at the time of the seizure to obtain provisional custody of the seized property pending a final forfeiture determination. This makes the time limit for filing a forfeiture action 21 days if the owner has filed a written demand for return of the property, or 90 days if the owner has not filed a written demand for return of the property. Provides that an owner whose property is returned is not liable for the cost of storage, transportation, or maintenance. Specifies how the proceeds of a forfeiture action are to be distributed. Requires a prosecuting attorney to report certain information concerning forfeitures to the prosecuting attorney's counsel. Imposes certain requirements on the use and compensation of outside counsel in forfeiture actions, and prohibits a prosecuting attorney or deputy prosecuting attorney from receiving a contingency fee for a forfeiture action. The introduced version of this bill was prepared by the Interim Study Committee on the Courts and the Judiciary. This is Senate Enrolled Act 99, effective July 1st, 2018. So, taking your phone. Interference with commerce, deprivation of rights. It's a lot of things. Okay. Now, you attempt to make a complaint. This is, again, a further deprivation of rights and conspiracy against rights. But it could, if your attorney says so, you could read up on this yourself, be covered by 42 U.S. Code 12203, prohibition against retaliation and coercion. Retaliation. No person shall discriminate against any individual because such individual has opposed any act or practice made unlawful by this chapter, or because such individual made a charge, testified, assisted, or participated in any manner in an investigation, proceeding, or hearing under this chapter. B. Interference, coercion, or intimidation. It shall be unlawful to coerce, intimidate, threaten, or interfere with any individual in the exercise or enjoyment of, or on account of his or her having exercised or enjoyed, or on account of his or her having aided or encouraged any other individual in the exercise or enjoyment of any right granted or protected by this chapter. The remedies and procedures available under sections 12(117) of this title shall be available to aggrieved persons for violations of subsections A and B of this section with respect to subchapter 1, subchapter 2, and subchapter 3, respectively. (29 CFR 1630.12) Retaliation and coercion. It is unlawful to discriminate against any individual because that individual has opposed any act or practice made unlawful by this part, or because that individual made a charge, testified, assisted, or participated in any manner in an investigation, proceeding, or hearing to enforce any provision contained in this part. B. Coercion and interference or intimidation. It is unlawful to coerce, intimidate, threaten, harass, or interfere with any individual in the exercise or enjoyment of, or because that individual aided or encouraged any other individual in the exercise of, any right granted or protected by this part. See what you guys are saying real quick. Solicitation used against aggressive. What's up, James? Solicitation laws, huh, Jingy? Huh. Trying to go pro se, Jingy. They don't want to let me no more. I'm gonna look that up in a second. I'm gonna print it. All right. Imparting or conveying false information. Title 18, USC 35. Whoever imparts or conveys or causes to be imparted or conveyed false information. Remember that. Knowing the information to be false. Concerning an attempt or alleged attempt being made or to be made to do any act which would be a crime prohibited by this chapter or chapter 97 or chapter 111 of this title shall be subject to a civil penalty of not more than $1,000, which shall be recoverable in a civil action brought in the name of the United States. Whoever willfully and maliciously or with reckless disregard for the safety of human life imparts or conveys or causes to be imparted or conveyed false information, knowing the information to be false, concerning an attempt or alleged attempt being made or to be made to do any act which would be a crime prohibited by this chapter or chapter 97 or chapter 111 of this title shall be fined under this title or imprisoned not more than 5 years or both. I will say they have nothing in order ever. Like it goes imparting or conveying false information, drive-by shooting, violence at international airports. (18) U.S. Code, Part 1, Chapter 1, Section 4. Misprision of a felony. Whoever having knowledge of the actual commission of a felony, cognizable by a court of the United States, conceals and does not as soon as possible make known the same to some judge or other person in civil or military authority under the United States shall be fined under this title or imprisoned not more than 3 years or both. Okay, so I just seen a what is it? New Chicago, Indiana cop on Indie Blue News' channel, and basically aggressive panhandling. They're pirates. And what did he say? Now, Indie Blue News, is pretty informed on this shit. But this cop comes up and is basically like, you can't record here. Federal building that's like a fucking police station in some small podunk town in Indiana. It's very small. They got like one paid officer, to my understanding, and everybody else is volunteer. So yeah, pretty small. Basically, he's quoting that it's illegal to record a federal building or some shit. They're quick to try to impose some sort of fucking local ordinance under the guise of federal color of law. By trying to restrict federal rights with made up federal law, they're acting under the color of federal law, which opens them up to a bunch of federal jurisdiction on all kinds of federal statutes. But there's a lot of interesting state stuff as well that you should like, specifically like this the computer trespass. That's an Indiana statute. There's also one that's like a nuisance action, offensive to the senses. All right. Damn, there's another one. Let me look around here for a second before I lose my train of thought. 42 U.S. Code 12-131. Basically, public entities are, what is it? The ADA prohibits discrimination against qualified individuals with disabilities on the basis of disability in the services, programs, or activities of a public entity. A police department is a public entity. Now, information. This in Indiana. Get it, it's backwards. This is an information. I swear under the penalty of perjury under Indiana Code 3544.121 that the foregoing is true and the information is the best of my knowledge and belief. Now, if you've ever been charged with a crime, you understand that you get a information written up by the police. This one just happens to come from Indiana Code 3533.1.4 regarding Indiana's citizens arrest procedure. Now, conveying false information. When a police officer lies under penalties of perjury, and an information oh my god, I would love it if that's really Nick Otis. Please. Indiana Code 34-17-1-1. An information may be filed against any person or corporation. 2. Whenever a public officer does or allows an act which by law works a forfeiture of the officer's office. Indiana Code 34-17-2-1. An information described in Indiana Code 34-17-1-1 may be filed 2. By any other person on the person's own relation, whenever the person claims an interest in the office, franchise, or corporation that is the subject of the information. Public servant, public interest, public action. One second here. Indiana Code 32-28-13-3. Public official means an individual who holds office or formerly held office at any time during the preceding 4 years in the executive, judicial, or legislative branch of 1. the state, or a political subdivision as defined in Indiana Code 511-10.5-11 in Indiana. Public place, Indiana Code 32-30-7-5. Public place means any place the public is invited by special or an implied invitation. All right, so public place, public officials, public process, protected rights. We get where it's all going. Damn it, kind of lost my train of thought here. Let's see something here. Give me 1 second here, folks. All right. All right, so Kevin R. All right. I filed 2 civil actions locally, one for public records, one asking for a full court or full bench ruling, 4 judges, Superior 1, 2, 3, and 4 here in LaPorte County. And I'm basically asking them to rule that the pat down order and the no trespass order was basically issued on a whim without any sort of authority or justification by an individual who didn't have that authority, at least not that authority to issue it in that process, basically. So legislative and executive powers and the crossover, and nobody's really explaining how they do it, so I'm accusing them of doing it the wrong way, because on the fucking paperwork that I got, it looks like they've done it the wrong way. The city attorney has responded that I've misinterpreted the statute, but they've actually provided no other reasoning. So what I'm asking for is a ruling on a, quote, uncertainty or dispute in the exercise of power. So that's still open. The public records thing, I've pretty much all but won. The city attorney quotes 13 pages. They provided me with 12, so I'm basically asking for the missing one. I'm also asking that they provide it in accordance with the judge's court order instead of under their bullshit as discovery material. All right, so in the court order, schmort order video, getting a little bit off topic, but I'll explain this. This is the Q&A part of the show. So as the if you've seen the court order schmort order video, not a problem, Kevin. Basically, you see he's quoting that he's going to appeal it. He's going to, he might file this, he might file that, blah blah blah. Well, he ends up filing a couple of those. The judge denies them all. Then he ends up filing basically with all these documents that he's been denying, he files them with the court to disclose to me. Yeah, he filed a motion to correct error. He filed a motion to stay the proceedings. His motion to correct error was denied. His motion to stay was denied. So then he filed a motion to disclose the actual documents. He provides the documents in the motion. I get them. And then the judge basically the judge enters an order saying that he'd like me to respond, that I've actually received the documents and such of this nature. I respond that I've received the documents, but not in the correct fashion according to the law. This dude's giving them to me for bullshit, a technicality. They arrest me, and then they arrest me as opposed to following the court order. But once I'm arrested for bullshit charges, then they give me the documents as discovery material in the bullshit charges. So, they give them to me as evidence in new charges that I only have because they refused to give them to me per the court order. You know what I mean? So that case is all but done. If there is, I don't know. He's fucking stupid. He probably miscounted. So I doubt there's an actual 13th document. But at this time, I'm just waiting on that shit. So yeah, they're fucking. Well, all right. Here's the thing: is what this dude's trying to claim is that he doesn't have to provide these because he might appeal. The thing is under Indiana's trial rules, that doesn't matter. The court order is in effect until something else says that it's not. So he can ask and piss and moan and what the fuck ever, but you see, he provided the documents. And if you watch my latest videos, they're a little less apt to deny shit. I've been getting paperwork handed to me left and right, because they figured out that one, he doesn't know Indiana's public records law, and two, it's kind of fucking pointless, because it's just paperwork, and most of it's pertaining to me, and I'm gonna get it anyway somehow, some way. And they figured that out because there's too many routes to get the fucking paperwork. Like, clearly, if I have to get arrested to get the paperwork, it is what it is. So, anyway. Yeah, I know. Everybody knows I'm crazy. It's interesting because I'm supposed to lose my shit and like commit some sort of fucking crazy act, and I'm really procrastinating here. You know, fucking, it's interesting, but that's still like a tactic. Anyway, so all these different steps throughout the process of auditing. You're recording, you interact with the police, they lie to you, they do all this bullshit. You know, they commit multiple acts that are all each their own isolated kind of illegal, or against some sort of statute or actionable in a civil court. Something you would possibly want to look into is the continuing violations doctrine and the failure to train theory. Failure to train theory is a section 1983 liability thing, basically. I'm not going to get into all of this. You look it up. Patterns and practices of RICO. We're going to get into RICO, actually. Let me see if there's a couple of other things I want to cover real quick. Indiana, real quick. In construing this statute, it has been held that any touching, however slight, may be constituted as an assault and battery. Shaw v. State, 239, Indiana, 248, 250, 156, 2D, 3D, 132, 1959. Any touching, no matter however slight, may constitute assault and battery, and neither degree of force used nor the injury sustained is material to the proof of an assault and battery. Shaw v. State, 239, Indiana, 248. Hamilton v. State, 237, Indiana, 298. Indiana, 1957. 2 years prior to Shaw v. State. Okay, so in Indiana, any touching, police put their hands on you in any way, shape, or form, and it's not lawful, it's battery. Okay. Indiana Code 354132. One second. A person is justified. What is that? That's 354132I. A person is justified in using reasonable force against a public servant if the person reasonably believes the force is necessary to 1. Protect the person or a third person from what the person reasonably believes to be the imminent use of unlawful force. 2. Prevent or terminate the public servant's unlawful entry of or attack on the person's dwelling, curtilage, that's the property around your house, or occupied motor vehicle. Or 3. Prevent or occupied motor vehicle. A person is justified in using reasonable force against a public servant if the person reasonably believes the force is necessary to prevent or terminate the public servant's unlawful trespass, unlawful entry of an occupied motor vehicle. Or 3, prevent or terminate the public servant's unlawful trespass or criminal interference with property lawfully in the person's possession, lawfully in possession of a member of the person's immediate family, or belonging to a person whose property the person has authority to protect. Now, it's Indiana law. It's like, you know, the only one out of the 50, I believe, that allows you to use up to and including deadly force, maybe fatal force. I haven't found that part of the ADA yet that requires you prove your disability. Pam. All right. Look, so let me address this Asperger's thing. For whatever reason, I have to prove over and over and over that I'm diagnosed with a neurodevelopmental disorder, as well as with the PTSD. I have to prove that I have a mental illness. Which, I don't know why the fuck people think that someone would falsely take this on and subject themselves to the public scrutiny that apparently this does when you can function in some fashions. I've noticed with the auditing community, specifically, the auditors are automatically, you know, with trolls and things of this nature, it's you're viewed as basically like someone who obviously has nothing else better to do. If you're pro police accountability or governmental transparency, and you put any time at all into this, it's too much time. You know, people, you know, why don't you find something else better to do? Which what they mean is, why don't you sit the fuck down at home and do literally nothing? Like, I've seen people that comment on my shit so much about why don't I get a job, which essentially, because I'm not dumb enough to fucking spell out where I work so that you can fuck it up. Like, I must not have a job. And it's like, part of it seems to be because, like, okay, I use the term disability because that's what people understand. I could get fucking real technical about how fucking cortisone levels during fucking development in the womb, based upon a mother's stress, basically create a fucking, you know, frontal cortex fucking issue. Disability sums all that shit the fuck up. So if I use the term disability, for whatever reason, it's not just trolls. I've noticed, you know, people, America, period. People tend to think that the word disability means that you get a fucking check. And it's, again, I do not know what fucking America you live in that the people who are in this position and literally are born this way and can do nothing about it and could possibly use a little bit of help. Like those motherfuckers, they don't even get help. So, I mean, are there a bunch of taxpayers lined up at my fucking door, like hiding money like Easter eggs in the yard, and I just haven't found it or something? Because I don't know. Like, I'm 33, and I believe my entire life I've been told that all the money that I put into Social Security, I'll never see because it'll be gone by the time I'm of age. So I'm fully expected to pay into Social Security, but I've accepted that I'm not going to get Social Security ever because old white people are going to get it and they're going to use it all up while they blame this whole, anything to do with governmental assistance on people of color. So I don't know what the fuck you think me having something different in my brain means that I get your tax dollars. As I said many times before, the government is spending a lot of your tax dollars flooding America with opiates. That's why we've occupied Afghanistan. That's why like 60% of Americans are on pharmaceuticals. It's not because somebody was like, "Hey, you need a fucking hand, buddy? We'll send you a check." Like, no, like it's fucking amazing to me that you're that delusional, like that you fucking think that I mean, maybe you're stupid, either one, but so just because someone tells you that they have something different in their fucking brain doesn't mean that they're to blame for your fucking tax dollars. Essentially, I don't know how the fuck you can pay taxes and think that this isn't your responsibility, for one. Yeah, convicted drug dealer. I gave a guy a dead plant. Anyway, so let's get back to business. Actually, I'm gonna go take a potty break. You guys, talk amongst yourselves for a second. Yeah, James. Strange how people with a job have time. One of my trolls just told me the other day that the reason he's so active is because he's laid in bed with a broken back, and I didn't have much time then, but I wanted to fucking respond like, so basically what you're saying right now is that you're unemployed. Like, you have time to comment on all my videos that I should get a fucking job because I don't make videos from my job. But you're literally unemployed right now, Anyway, I'm gonna go take a restroom break really quick. brought up a very good point, Kevin. Why does my prior arrest, okay, let's say you grow up in America and you have no interaction with the justice system until you get arrested, you pay your debt to society, whatever the fuck that means, because there's no such thing as an ex-felon. Anyway, where exactly do you think that you're going to be taught the way that the justice system works, really works? Like, I think the justice system a lot of times is bullshit. But you know where I've actually seen it work the most, where I've seen evidence of it working? In prison. I've seen people who need to fucking be there because the law works. It's where my sliver of respect for the law works. Like a police officer was recently just convicted for raping a handicapped woman. Convicted. He's about to go to prison. Badged it, protecting. The law worked. Now, expecting the people who enforce the law to know the law, follow the law, be willing to inform you about the law, that's neither here nor there. That's neither felon or non-felon. Like, expecting a police officer to, like, at bare minimum know the laws that he's claiming he's literally there about to arrest you because he's enforcing, that's not something that just someone who has no criminal history can do. Like, the purpose of incarceration is ideally so when you are done with your time, your debt to society, you don't want to go back. Like, you developed this, you know, you're going to be a productive member of society. Being a member of society is separate from the productive part. Being a member of society is basically you're willing to obey the rules and laws of society. So it's like, this is the goal, but it comes as such a shock if it happens. Like, if you get out of fucking jail and you, like, don't get in trouble anymore, and then you, like, all of a sudden start noticing that people are getting away with crimes left and fucking right. So you start asking about accountability and transparency. It's like a police officer asking if you're a lawyer when you start telling him the laws. Right, exactly. That's a very good point. If you are interacting with a police officer, they will tell you they're there to enforce the law. And if you say, what law is it? A lot of fucking, who knows what they're going to say? None of your business. I'll figure it out later. Blah, 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 blah. Hi, Regina. But then if you respond with knowledge of the law, which it's not that fucking hard to figure out the law these days. Like, they want you to fucking know the law. They want you to know it so that they can hold you accountable to it. But the police can not know the law, and then when you know it, man, I swear to God, it's like 8 times out of 10. Where did you go to law school? Or now they get even fucking more demeaning with it. Did you got a YouTube law degree? Like, no, I don't. I didn't know YouTube offered law degrees. Be amazing to be able to fucking do all this online, but that's probably not going to fucking happen. However, you don't need a law degree to be informed about the expectations that your society has literally fucking voted on or ignored the process for voting upon all these rules and regulations and restrictions for you. You're somehow not able to fucking read the law unless you go to law school, which is fucking ridiculous. Like it's just absurd. Like I can't even begin to explain how absurd it is to think that you can't believe everything you read on the internet. Like, I've literally had a fucking cop tell me I can't believe everything I read in books. Like, some books are accurate, officer. And just because something's available online in 2019 doesn't mean it's not true. Like, I've seen cops tell people that you know, where'd you read that? On the internet? And then turn right the fuck around. I'm gonna look that up. Fucking smart YouTube lawyer guy, I'm gonna look that up. Where'd you get that fucking... Where'd you learn that? On the internet? Hold on. What'd you say that Indiana code was? Oh, fucking... Huh. This says you're right. Well, you know, that doesn't fucking matter anyway. And blah, 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 blah. Fucking watch it happen. I've seen plenty of fucking videos where that shit happens. And, like, how in the fuck can you enforce the law if you don't know the law? Like, I get it. I'm fucking crazy for asking this question all the time. You know, they treat me like I'm some sort of a fucking lunatic, but it actually baffles me. Like, I'm not even being funny. I can't wrap my fucking brain around how someone could possibly hold another individual to a standard that they don't fucking know. Like, you're breaking the law. What law? Huh? Exactly. Like, what law? What do you mean, what law? What the fuck are you talking about then? What are you here to do? You know what I mean? It's just they're like willfully ignorant, because they'll know the law when it comes to like the dumbest shit, to be honest. Like, stupid shit. I've seen cops that they don't know the basic important fucking shit, but they know ignorant, trivial fucking nonsense that doesn't really apply to what their agenda even is, let alone to what the fuck they're really supposed to be doing. But anyway, yes, mostly try to force their opinion. I mean, because after all, they're people. Like, small towns are the worst, in my opinion. Small towns seem to not know the laws at all. They just go off of, there's fucking 150 people, 300 people in their town, and they got the 3 badges, so everybody just fucking lets them do whatever the fuck they want, and people don't really challenge it, and yada yada yada. So the small towns are the worst. They typically seem to know the laws the least amount, and they're the ones that seem the quickest to throw out that you're in violation of a federal law, as opposed to their own fucking state laws. So it's definitely problematic, and the dilemma with all this is that exactly. You can know this shit inside and out, but if, like, the police don't, you're always going to end up arrested. So they're going to play the whole tell it to the judge, and then you got to fucking go through all that with court and all this. So, I mean, if you know your shit and you're going to drag it the fuck out and cost a bunch of money, and they know that you're not going to plead guilty, and they know that the evidence is bogus, they'll drop it. I mean, they they can't afford to lose at trial to make a fucking point unless it's like, unless they're fucking really serious about it, unless you pissed them off enough. But by then, if you, hopefully you know your shit. Freeman is entertaining. Honestly, the Necio running around as in a pig suit as qualified immunity with his blue line flag cape, and I think he had like a strap on that he was jacking off while he's giving the cops the finger. I'm waiting for one of them to get shot. Like then, you know, Swine's 50-50. So it's, but yeah, the pig suit is brilliant, but yeah, no, I wouldn't do the. That's another thing I've noticed. You made me think of that. Whose video? I was watching Indie Blues video the other day. He kind of didn't talk to him, so they immediately were like, "Do you need medical attention?" So this is, I wouldn't. You mentioned the asking the police if they need public accommodation so they can keep their shit together. It just made me think of that. But yeah, it's something to look out for too. Is yeah, another way to hem you up. Exactly right, Kevin. Because most places, most states have a have them around here somewhere. Civil commitment statutes. You know, emergency detention, whatever, anywhere from 24 to 72 to 30 to 90 days, depending on what state you're in. Indiana's got one. A police officer can arrest you for having a mental illness. Like, they can just determine that you have a mental illness and you're a danger to yourself, and they can arrest you and charge you with having a mental illness. So, you know, ordinarily, you know, with the, you know, how you interact with police officers is your choice, but something to be wary of, that they, you know, if you hear that medical attention thing, might be a good idea to respond, let them know that you're all right, that you don't need medical attention. To be honest, if you're somewhere you're not familiar with, I might even open with that. And that's it. I don't need medical attention. I'm all right. I don't need any help. I don't need any assistance, officer. You know, obviously if you're recording and everything, so cover your bases there. But yeah, that's another one I've seen a lot. Different people's videos. They try to use it to hem you up. It's pretty much like the "you went left of center" or "I smell marijuana" for auditing. You know what I mean? The fail safe. Anyway, what else were we going to get into here? We're pushing it. Civil RICO. Let's read about Civil RICO. Jurisdiction and venue. By the way, this is not legal advice. It's from my personal writings that I'm doing here. I will be filing. Jurisdiction and venue. 28 U.S. Code 1331. 28 U.S. Code 1343. 28 U.S. Code 2201. 42 U.S. Code 12203C. 42 U.S. Code 1983. 42 U.S. Code 1985. 42 U.S. Code 1986. 18 U.S. Code, 42 U.S. Code 1988. 18 U.S. Code 1961C. 18 U.S. Code 1961D. 42 U.S. Code 12205. 28 U.S. Code 1391. Assessor v. Indiana University Board of Trustees, 581 F3D 599 602 through 03, 7th Circuit 2009. Tamayo F26 or 526 F3D at 1081 and 1083. At a minimum, the complaint must give the defendant fair notice of what the claim is and the grounds upon which it rests, and the factual allegations must raise a right to relief above the speculative level. Anyway. Civil RICO. To recover under 1962C, a plaintiff must prove 1. Conduct. In determining whether the conduct element has been satisfied, relevant questions include whether the defendant occupies a position in the chain of command, knowingly implements the enterprise's decisions, or is indispensable to achieving the enterprise's goals. Walter V. Drayson, 538 F. 3rd, 1244, 1248 through 49, 9th Circuit, 2008. 2. Of an enterprise. 18 U.S.C. 1961 4. Enterprise includes any individual, partnership, corporation, association, or other legal entity, and any union or group of individuals associated in fact, although not a legal entity. In particular cases, the evidence used to prove the pattern of racketeering activity and the evidence establishing an enterprise may overlap. Boyle, 556 U.S. at 947. An enterprise includes any individual, partnership, corporation, association, or other legal entity, and any union or group or individuals associated in fact, although not a legal entity. 18 U.S.C. 1961 4. The definition is not very demanding. Odom, 486 F. 3rd at 548. RICO does not require that either the racketeering enterprise or the predicate acts of racketeering be motivated by an economic purpose. National Organization for Women Incorporated versus Scheidler, 510 U.S. 249, 262, 1994 case. An associated in fact enterprise is a group of persons associated together for a common purpose of engaging in a course of conduct. Boyle v. United States, 556 U.S. 938, 945 through 946, 2009, quoting United States versus Turkett, Turkette, 452 U.S. 576, 580, 1981 case. Its existence is proven through evidence of an ongoing organization, formal or informal, and evidence that the various associates function as a continuing unit. No particular organizational structure, separate or otherwise, is necessary for an associated in fact enterprise. Odom 486 F3rd at 551. 3. Through a pattern. Actually, here. A plaintiff, to recover under 1962C, a plaintiff must prove conduct of an enterprise through a pattern of racketeering activity known as predicate acts, causing injury to the plaintiff's business or property by the conduct constituting a violation. Okay. 3. Through a pattern. 18 U.S. Code 1961-5. Check what you guys say in here real quick. Oh. While we're at a little intermission here, say thank you to the mods. One of my lives last week, I think it was the 11th hour fun, somebody looked out real well on the PayPal. So you know who you are if you watch this. Thank you very much. Working on getting some new gear, so appreciated. And thank you to my mods. You guys make it a little bit easier. Can't say enough. Thanks. No, I kind of wonder if it was really him or one of my trolls. I kind of hope it was him. We didn't block him, did we? I hope he comes back so we can talk about Indiana Code 334318, deceit or collusion of attorney. Spoiler alert, it's got treble damages in the statute, so gotta love that they've contracted with an entire firm, and I'm not going to be able to just claim that it's his actions. I'll get to claim that all 11, 12 attorneys at the firm are responsible according to their contract. So I get to go with the whole firm. It's lovely. Thank you, James. Do you want to throw your money away? You enjoy watching this kind of thing for whatever reason. Let's drop the PayPal there for you. Have you know I don't drink booze, I drink coffee and smoke cigarettes, but it's essential to this. No great work is completed without coffee and cigarettes. It's just part of it. Just the same. I'd like to quit smoking. Anyway, moving along. 42 U.S. Code 1791 B8, intentional misconduct. Conduct by a person with knowledge at the time of the conduct that the conduct is harmful to the well-being of another person. Just thought I'd drop that out there real quick while I've seen it. Anyway, going back to the RICO. Through a pattern, 18 U.S.C. 1961-5. Pattern of racketeering activity. requires at least 2 acts of racketeering activity, one of which occurred after the effective date of this chapter, and the last of which occurred within 10 years, excluding any period of imprisonment after the commission of a prior act of racketeering activity. A pattern is defined as at least 2 acts of racketeering activity within 10 years of each other. 18 U.S.C. 1961, 5. To establish a pattern of racketeering activity, the predicate acts must be both related and continuous. C. Related conduct embraces criminal acts that have the same or similar purposes, results, participants, victims, or methods of commission, or otherwise are interrelated by distinguishing characteristics and are not isolated events. D. Relatedness of the alleged or proven acts is rarely an issue. 4. Of racketeering activity, known as predicate acts. A. In particular cases, the evidence used to prove the pattern of racketeering activity and the evidence establishing an enterprise may overlap. Predicate acts must be proved by a preponderance of the evidence. Wilcox v. First Interstate Bank. To constitute, by the way, I'm not dropping all of these case citations on here just because I'm not trying to show my full hand, to be honest. To constitute a racketeering activity, the relevant conduct must consist of at least one of the indictable predicate acts listed in 18 U.S.C. 1961. Racketeering activity consists of no more and no less than commission of a predicate act. Now, 18 U.S.C. Code 1961, as used in this chapter. 1. Racketeering activity means B. Any act which is indictable under any of the following provisions of Title 18 United States Code. Specifically, Section 1512, relating to a tampering with a witness, victim, or an informant. So, I'm going to read that because this is the important part. This is where civil RICO comes into auditing. Okay, now, should you videotape and it goes bad and they do all these things, yada, 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 you go to file a complaint. You may be tempted to FOIA some information. Yes, sounds like all police would fall into a civil RICO, as well as the attorney, the mayor, the city council, all the people that help the police cover up their crimes would also fall under civil RICO. At least they're going to in LaPorte. Anyway, you go to file a complaint. You go to get information. You want to see the police report. You want to see whether there's disciplinary reports, which in Indiana you would be entitled to the factual information for a police report under Indiana Code 514.3.5. But the green one. We're going to go into this for just a second so you can see how I got to where I am in my stuff. Just take a quick second to answer some questions. Looking for a very specific thing here. Anyway, it doesn't matter. Okay, so I'm entitled to the basic police reports, public records. Okay, so I'm trying to go get public records. The police are there to prevent me from getting these public records, which is, in my opinion, tampering with a witness as a qualifier for RICO. Anyway, it's 514.3.5 for a police report in Indiana. Basically, you go to get police report, prior disciplinary actions, whatever you FOIA or public records request, whatever the terminology is in your state. And, you know, they show up and they do what they do to intimidate you and harass you and basically try to avoid or try to interfere with you making your complaint or getting information. Now, here's another thing is if you interact with an attorney for whatever that represents this entity and they're going to tell you something along the nature of its attorney work product, which is in anticipation of litigation, or if you inform them, which if your plan would be to go for RICO, it's might as well nip it in the bud and from the beginning inform them that, you know, should they violate your rights, what recourse you're going to take. Any action after that to interfere with your ability to obtain the documentation, the factual information that you're going to use in something like a, let's say, your basic 1983 civil suit. A 1983 civil suit is to be filed in a federal court. A federal court would mean that that's an official proceeding. You would be an individual that's going to testify in an official proceeding. If you intend to file a 1983 lawsuit, you intend to testify in an official proceeding, which is in a federal courtroom. Long story short, 18 U.S. Code 1512, tampering with a witness, victim, or an informant. Whoever uses physical force or the threat of physical force against any person or attempts to do so with intent to influence, delay, or prevent the testimony of any person in an official proceeding, cause or induce any person to withhold testimony or withhold a record, document, or other object from an official proceeding, alter, destroy, mutilate, or conceal an object with intent to impair the integrity or availability of the object for use in an official proceeding, evade legal process, summoning that person to appear as a witness or to produce a record, document, or other object in an official proceeding, or be absent from an official proceeding to which that person has been summoned by legal process, or hinder, delay, or prevent the communication to a law enforcement officer or judge of the United States of information relating to the commission or possible commission of a federal offense or a violation of conditions of probation, supervised release, parole, or release pending judicial proceedings shall be punished as provided in paragraph 3. The punishment for an offense under this subsection in the case of the use or attempted use of physical force against any person, imprisonment for not more than 30 years, and in the case of the threat of use of physical force against any person, imprisonment for not more than 20 years. So, interference with the paperwork process sounds serious. If I was a police officer or a municipality, probably wouldn't be my goal. You guys give me a moment here. I'm going to let one of my puppies out real quick. And we're back. James. RICO does not require that either the racketeering enterprise or the predicate acts of racketeering be motivated by an economic purpose. National Organization for Women Incorporated versus Scheidler. SCHEIDLER 510 US 249 262 1994. A RICO conspiracy under 1962D may be established by proof of an agreement to commit a substantive violation of RICO. It is the mere agreement to violate RICO that 1962D forbids. It is not necessary to prove any substantive RICO violations ever occurred as a result of the conspiracy. The conspirator need not have agreed to commit or facilitate each and every part of the substantive offense. However, the conspirator must have been aware of the essential nature and scope of the enterprise and intended to participate in it. The agreement need not be express as long as its existence can be inferred from words, actions, or interdependence of activities and persons involved. A defendant can be held liable for a RICO conspiracy if the evidence shows that he or she knowingly agreed to facilitate a scheme which includes the operation or management of a RICO enterprise. Section 1962D applies to intracorporate as well as intercorporate conspiracies. Thus, it is possible for a corporation to engage in a RICO conspiracy with its own officers and representatives. Now, keep in mind, a corporation, like a municipal corporation, which is a municipality, that's your local, municipality. It is possible for a corporation to engage in a RICO conspiracy with its own officers and representatives. That's Webster versus Omnitron International, 79 F3rd 776 787. Quoting, with approval, Ashland Oil Incorporated v. Arnett 875 F. 2nd 1271. That's from the 7th Circuit. For the proposition that intracorporate conspiracies threaten RICO's goals of preventing the infiltration of legitimate businesses by racketeers and separating racketeers from their profits. Yeah, most of this is ADA stuff. We're not going to get into all that tonight. Anyway, for those consistently asking about RICO, we're getting there. This is 44 pages, so I'm trying to shorten it up a little bit, but I got a bunch of new shit to add, so that's why they give you 4 years. What else? I think that's about it, guys. Yeah, I'm gonna wrap it up. Oh yeah, no. Got something special. All right, So, this is for my my locals. Indiana Code 5.14.3.4, version A and B. Lowercase b 8. This is an exception. Personnel files of employees and applicants are confidential except for C, uppercase C. The factual basis for a disciplinary action in which final action has been taken and that resulted in the employee being suspended, demoted, or discharged. Specifically, police officers is what I will be applying this to. As well as here in Indiana, Indiana Code 2530 1.35. A security guard agency means a person that is in the business of providing for hire or reward a guard or other individual to protect persons or property or prevent the misappropriation or concealment of goods, wares, and merchandise, money, bonds, stocks, chosen action, notes, or other valuable documents or papers. Indiana Code 2530 1.37. A person may not engage in business as a security guard agency unless the person is licensed as a security guard under this chapter. So, you can stop by a security guard in Indiana, 2530 1.37. You can go ahead and ask them for their license. Just the same as you can ask an officer to identify themselves with their badge. Then, oh yeah. We're going to do our Buck the Police quote of the week now. All right, we have an Officer Nathan Thode. He's listed as a specialist here at the LaPorte Police Department. Made around $50,000 or something in 2017. He seems to be getting about a $2,500, $3,000 raise every year. So probably more this year. Anyway, so in my conversations with Officer Thode, I'm basically asking him why he's recording me, because Indiana law makes it illegal for officers to document people's political activity. He did not disappoint. Basically says he's, and I quote, "I'm not investigating a crime. I'm just documenting," which is, interesting, because my initial interactions with the LaPorte Police Department was where they were very concerned that I was videotaping them, and I explained that I was documenting. They were very nervous and uncomfortable about this, locking buildings down, things of this nature. Furthermore, in this conversation with Mr. Thode, he explained just how much of a waste of a time it was to be investigating something that's not a crime, and said, "I can't help the victims." To which I said, "What victims?" I treat me like I'm fucking, a criminal all the time. I assumed that you meant the victims of me, the state of Indiana and the city of LaPorte and these people these entities that they keep quoting as victims. "I can't help the victims." "What victims?" Mr. Thode says, "Of my caseload that I have." I say, "Right." He says, "Because I have to be here, so you're taking resources away." "I'm taking resources away." "Resources away from what?" He says, "Do you know I have a stack of cases?" "I bet you do have a stack of cases, Mr. Thode." He has a stack of cases with victims. "I can't help the victims of my caseload that I have. Do you know I have a stack of cases?" Stack of cases, caseload. Those are the same fucking cases, aren't they? So he's got a stack of cases, stack of victims, shit tons of victims, and I'm taking resources away because you're recording me not committing a crime so that you can prove that when you committed crimes against me, because I was recording, it was okay. Fuck your victims, right, Officer Thode? No. Fuck you. And fuck the police. So, yes, that's been our fuck the police quote of the week. Officer Nathan Thode with the Port Police Department. You can go ahead and give them a call if you want. Damn it. I don't have their number readily available. Yeah, you could look them up. Tell them maybe Officer Thode could fucking get to his caseload of victims, because that's what the fuck the city of LaPorte is paying for him to do, is tend to actual victims, not document political activity. Yeah, he did give me one of the best videos yet, Civilian X. Fuck. I mean, the chief of police's face when I tell him that I can't work there because I'm a felon, and that one was pretty good. But Thode gave me some great B footage. Like at one point in the video, he was there. This was the Board of Works meeting. Oh, I gotta go let my dogs in. It's getting kind of late and they're getting loud. 1 second. All right. So yeah, at one point, he says, he doesn't even know anything about the conversation from the night prior because he wasn't even in the building. And sure as fucking shit, he's in my video. I talked to the dude the day before, and Officer Thode, if you're watching this, you're literally the only motherfucker running around with I don't even have a fucking tripod. I mean, I have a tripod, but I don't bring it to City Hall with me. But you're literally the only motherfucker there running around with a tripod. I don't know how in the fuck you thought it was going to be like impossible to identify you, or maybe you thought that I wasn't fucking recording. I don't fucking know. But he, like, in the second video the next morning, he, in the conversation, like, gets this smug look on his face, like, and leans back and is like, And it's right after he says, I wasn't even in the building. And it's like, in my head, there's always these thoughts that go through where they say some stupid shit. And I'm just like, what the fuck? Like, that's that video the whole time. I'm just in my brain, like, I have to be drunk. Like, I must be drunk because this motherfucker, like, you're a detective and you don't even remember talking to me. Yes, I'm the motherfucker you're here videotaping, and you don't even remember talking to me yesterday. And you're so fucking sure of yourself, you just want to talk shit, that you literally claim to not be, like, in the building. Like, we videotaped each other pretty much in passing. Like, I'm on your video, you're on my video. Like, I don't know how the fuck you... But sure as shit, one of the better videos, yes. They say some ignorant shit when I just let them talk, and I mean, might be the one reason for me to just shut my mouth is because they'll say something stupid. Like, it's yeah, it's one of the better videos. Anyway, definitely fuck Officer Thode. Can't help his victims because he's just doing what he's told. That's what he said. He's just doing what he's told. Doesn't want to be there, and basically what he was trying to convey was frustration in doing what he was told as opposed to what he needed to do. So this touches on when an officer knows what is the right thing to do and when he does what the fuck he's told. That whole good cop, bad cop thing. Don't let the bad apples spoil it. What the fuck ever. Like, doesn't matter. They tell good cops to do bad things all the time, and they fucking do it. Every once in a while, they'll admit to it right on video with a shit-eating grin on their face like they said something that's fucking smart. Yeah, I will stand here and argue with you all day. I don't care. Like I got what is it, Officer Daniel Reed, and in my February 5th, 2016 video says, I'm making pretty good money to stand here and get called names. Like, yeah, you fucking are. Like, I have, what is it? I got a video from October of 2017 where they locked me out of the building for like 2 hours as I'm trying to attend city council because I refused to be patted down, according to their bullshit city attorney's love letter to me. That same week. That same week, they let a local EMT go because one of the officers knew him, and the dude was trash drunk in a Mustang, killed 2 people. They owned a local pizza place that everybody loved. Damn good pizza. Officers are still there. Like I said, we'll be asking for factual basis for a disciplinary action in which final action has been taken that resulted in the employee being suspended, demoted, or discharged. I got a hunch that suspended is going to apply to Dan Reed because he was MIA for a while. But you know, a judge called these motherfuckers, quote, disgraceful. You know, basically dereliction of duty, things of this nature. To my knowledge, nothing's happened with it. You know what I mean? And I mentioned this in the video with Officer Thode, and he says something about, that's my side of the story. You know, there's 2 sides to every story, but this is my side of the story, is that these 2 people are dead and that a judge on the record called them disgraceful. It's my side of the story. You know what I mean? And they're so fucking indoctrinated with this thin blue line camaraderie brotherhood bullshit that, like, his coworker is responsible, 3 of his coworkers are responsible for 2 people's lives lost. And this motherfucker looked me right in my eye and tried to tell me that was my version of the story. Like, I've seen the fucking articles, you know, their grandkids talking about how the woman would have celebrated her birthday on this day, you know, the picture of the grandkids in front of the you know, her tombstone. You know, I shit, it's there. There's the EMT. There's the judge. That I got currently right now. But let's see what the Officer Thode says is my version of the story. Page A3. I want these officers held accountable. I don't know how they sleep at night. Family of the victim. Okay. Bergerson also took the LaPorte officers to task Thursday for unbelievably giving a pass to the defendant, in whose vehicle 2 bottles of Canadian Mist whiskey, 1 empty and 1 partially empty, were discovered after the crash. The conduct of Sergeant Patrick Cites, if you watch my videos, that would be accused of battery. It's a part 2 video. The officer who I talk about his Facebook, and you know, him having pictures of you know memes talking about drowning people and racist shit and all kinds of, you know, if don't be a thug if you can't take a slug, shit like that. Anyway, I start talking about this dude's racist Facebook post, and that's what I actually get arrested for, because it's self-defense. Clearly, the cop actually writes up the fucking report, pretty much describing it as the dude tried to take my phone and there's a scuffle. So this is one of these cops. He's still on the force. Yep. Probably did read an article on this. Yep. The prosecutor who prosecuted this dude and questioned these cops ends up in an article claiming that she was fired for requiring this testimony to be so truthful. And she calls for accountability as well. So, like, she doesn't work there no more, and she's claiming this is why. Anyway, the conduct of Sergeant Patrick Cites, Corporal Dan Reed, if you watch my videos, February 5th, 2016, that's Dan Reed. He's in a couple others as well. And Officer Robert Hagler anyway, the conduct of Cites, Reed, and Hagler amounts to a clear dereliction of duty, which I find to be unconscionable, shameful, and embarrassing, Bergerson said. Judge Michael Bergerson. Officers Cites, Reed, and Hagler disgraced themselves and seriously undermined the public confidence in law enforcement. Without a doubt, their failure to honor their mission to serve and protect indirectly contributed to the deaths of Donald and Angela Kazmarek. The judge's tone reached a yell when he recalled how each of the three officers testified they did not smell alcohol on Gorbunazinko, contrary to the testimonies of multiple witnesses at the scene. Their testimony was an insult to the intelligence of the court and to the members of the jury, Judge Bergerson said. Such disrespect by officers sworn to uphold the law is hard to fathom, and their accountability is better addressed in other forums, times, and places, hopefully. Hopefully indeed, Your Honor. We're going to fucking look into it, probably Monday. So, if you watch my videos, just know, Monday, I'll be to ask about the disciplinary fucking proceedings that should have happened against these three officers. They should have been fucking fired immediately. They let a drunk motherfucker go because he was their buddy. And he killed two people who didn't deserve to die simply because they weren't protected by law enforcement when they had the opportunity to be. You know, these cops pulled this motherfucker over and then they let him go. You know, and it's interesting because Officer Reed is the one that's supposed to have known him, from what I understand. And Officer Cites, I believe, implicates this notion as well. I believe he testifies that Officer Reed was friends with the EMS guy. And basically, Officer Reed testified that he did not smell alcohol. He was very adamant that he did not smell alcohol on his buddy who was about to catch a fucking DUI and probably lose his job with the county 911 folks. So they let him go. But Officer Reed, if you notice in my February 5th, 2016 video, is very clear that he can smell cigarettes on me and that he can't wait for me to get outside because it's going to be funny, and that if he wanted to touch me, he would touch me. And how none of this was on video because I just needed to rewind my video. I'm making things up. Like, the dude's fucking stupid. Anyway, it's just interesting because this dude's still a cop. You know what I mean? I believe they might have put him on leave, but I believe he was the only one that went on leave, and it wasn't for that long because he's back. And that might not even have been why he was on leave. From what I understand, I think he had a shoulder injury or something as well. So when I noticed that he was missing in action for a while, that might have just been some medical shit. Just the same, I believe the city paid these folks about $700,000. So, you know, they didn't dispute it. But they still got these cops. You know, they paid the money out. Judges are calling them a bunch of fucking dumbasses, all but calling them liars. It's on the front page of the newspaper how these officers still employed. Because I'm the citizen, and this is my side of the story. Shit's on the front page of the fucking paper. My side of the story, according to Officer Thode. And this is how cops get away with shit. Is Officer Thode thinks that it's just some sort of misunderstanding. I've got my facts incorrect. I'm misquoting. I'm diluting the information. How I'm taking it out of context. How the fuck? I'm pretty sure these two people are fucking dead. You know what I mean? Pretty sure these cops are responsible. Pretty sure that it's fucking pretty plain English. I mean, the fucking newspaper is quoting a judge on the front page. I don't think it's just my side of the story, but that's what happens is officers have these kind of conversations. They would say that given their pension, but when they have a conversation with the citizen, no matter what, they're going to try to stick up for their buddy, even in the face of obvious misconduct. I'm talking obvious misconduct. Like there's a fucking judge on the front page of the paper calling you disgraceful, using terms like dereliction of duty, calling for you to be reprimanded in some way, shape, or form, and even acknowledging that you probably won't be. That's his last words. Hyphen, hopefully. Hopefully they address this in another forum. But he even this judge knows they're not likely to, and he's willing to explain it to the public. So this is how they get away with it. You know what I mean? It's something like this is covered under the Police Merit Commission. And if you watch my videos, you've seen how Police Merit Commission meetings go. The officer has all sorts of rights. They're very willing to protect these officers' rights to let people die due to negligence. Anyway, that's about it. Shit, right about pushing a 2-hour show. I was shooting for 1, but fun. As always, I'm gonna try to do this every Friday night at 9. We won't put an end time on it just to be safe, but try to start at 9 every Friday night. If you're not trying to go do the party scene or at the bar or whatever, you know what I mean? If you're a homebody and you watch the videos and whatnot, Friday nights at 9, we're gonna kick this off. I'll try to make it a a worthy evening of entertainment. So like I said, thanks to my mods. Big thanks to the PayPal donations and everything. Thanks for watching these. I do enjoy sharing, the information. Do enjoy sharing my experience. Hope to learn from others as well. I enjoy the little back and forth in the chat. But yeah, like I said, I'm gonna try to do these every Friday. And see how much of this research I can't get out there into the video world. It's not just about auditing them, it's reporting their fuck ups as well, and you can't count on really any part of their process to be facilitated by them. You know what I mean? They're not going to help you get them in trouble, so you got to figure out the process. I think next Friday I'm going to try to get into some state forms for Indiana, as far as some other stuff like retention schedules, just some other documents that I found that if you're going to pursue this path, in my experience, these are things that I have had to reference a lot, like a retention schedule. If you're asking for public records, make sure they got them. You know what I mean? Like here in Indiana, what is it? The security footage for like the in the county jail lobby and whatnot, they only hold that for like 30 days, I think. 30 days on the retention schedule. So just some stuff like that I'm going to get into next week. Lesser stuff that you wouldn't really think of, but that once you get into this, you're going to find that you reference a lot. A retention schedule is one of them. Every state's got their own. The feds got their own. you know. Then we're going to get into different levels of local rules for court. You know what I mean? You have your I might say that for another episode. That's a long one. Yeah, I don't know. We're gonna get into a bunch of stuff. Probably touch on qualified immunity as well. Anyway. Yep, class is over. I'm out. Thank you, everyone. Thank you, Jingy. Thank you, Civilian X, James. Everybody's watching tonight. All the lurkers. Joe Black. Thanks for modding, James. But yeah, I'm gonna cut this off. I gotta go get me some food, replenish. Yep, no problem. You guys stay safe. Maui NBA. Thank you, sir. Like I said, try to do this every week. If I end up canceling one, I try to either do it on like the Thursday before or the Saturday after or something. But I'm gonna try to get at least one of these lives, you know, Friday night Cites, you know, at least, you know, good hour every Friday. But until next time, who knows what I'll upload in between there, but definitely doing this every Friday. Thanks for watching. Have a good night. Stay safe. Keep them honest.